Just now, the constitutional dam breaks. Attorney General Pam Bondi implicates the president in open court. This is not a leaked memo or an anonymous rumor. This is a sworn admission from the highest law enforcement officer in the land. Hello. I'm Rachel Maddow. We are currently navigating what can only be described as a historic inflection point in the American experiment, occurring in the early morning hours in the District of Columbia. I have been reading the official court transcript since it dropped just moments ago, and what happened at 9:44 a.m. this Saturday, April 25, 2026, has fundamentally changed the legal landscape for the executive office. The setting was the U.S. District Court for the District of Columbia. The presiding judge was Sullivan, a man known for his literalist interpretation of the law and his intolerance for administrative delays. The day began with a 9 a.m. deadline for the Department of Justice to produce a full, unredacted inventory of the long-shrouded Epstein documents. For months, the public has waited for the truth behind these files. Instead of transparency, the DOJ submitted what legal experts are calling a defiant inventory. Even after months of subpoenas, the list arrived with 41 key names still blacked out, hidden from the eyes of the court. Judge Sullivan did not hesitate. At 9:07 a.m., he took the highly unusual step of calling Attorney General Pam Bondi directly to the witness stand for questioning. He bypassed the lower-level litigators and went to the top. I want you to imagine the atmosphere in that room. The Attorney General of the United States, placed under oath, facing a judge who had already issued a clear production order for every single page of those documents. Judge Sullivan began his inquiry by asking if these specific redactions were based on independent legal judgment, or if they were the result of outside influence. For 30 minutes, the tension in the courtroom was suffocating. At 9:34 a.m., Sullivan asked point blank, "Were these names removed based on a valid legal privilege, or were you told to hide them?" Bondi initially attempted to pivot, citing guidance from the executive office, but Sullivan pushed harder. He demanded to know exactly who gave that guidance, and then came the moment that will likely define the remainder of this presidency. It happened at exactly 9:44 a.m. There was a 14-second pause. 14 seconds of dead silence in a packed federal courtroom as the Attorney General of the United States looked at the bench. Then she spoke with a clarity that stunned those present. The president communicated that certain materials would not be produced. That is the quote. It is on page 14, line 6 of the transcript I am holding in my hands right now. Bondi admitted under the penalty of perjury that the decision to suppress the names of 41 individuals in the Epstein files was the result of direct executive direction from Donald Trump himself. This is a seismic shift. Let's be very clear about the legal gravity here. This isn't a policy disagreement. This is the Attorney General admitting the president ordered the DOJ to ignore a standing court order to produce evidence. The timeline is the key. Bondi testified that this specific communication from the president occurred on April 19, 2026. Why does that date matter? It matters because it happened after Judge Sullivan issued the production order. Legally speaking, when an executive official directs an agency to ignore a judicial mandate, you move past the shield of executive privilege. You are now standing in the territory of criminal obstruction of justice. By 10:12 a.m., Judge Sullivan called the admission extraordinary and immediately suspended the proceedings. He realized the court was no longer just looking at a records dispute, but a potential crime in progress. The 41 redacted names are at the heart of this storm. Reports suggest that at least 3 of those individuals were previously identified in unsealed filings as uncharged co-conspirators. The stakes could not be higher. The White House scramble began at 10:47 a.m., with the press office issuing a statement calling Bondi's testimony imprecise. They are claiming the guidance was general and protected by privilege, but the transcript says otherwise. By 12:47 p.m., the political fallout became bipartisan. Senate Judiciary Chair Dick Durbin and Ranking Member Lindsey Graham announced a joint emergency hearing for Monday morning. They are calling this a constitutional crisis scenario. The Graham factor is significant. The senator has been a staunch ally, but his participation in this emergency probe suggests he has seen whistleblower evidence that confirms Bondi's account. The Republican wall is showing major cracks. We have also learned that Bondi hired personal counsel 4 days before this hearing. She knew she was on a collision course with the White House and chose self-preservation over administrative loyalty. She went in prepared. This is the first time a sitting attorney general has attributed potential criminal obstruction directly to a president in open court since the Watergate era. The next 48 hours will determine the health of our institutions. The White House has until Sunday midnight to file a formal privilege assertion to strike Bondi's testimony. If they fail, or if Sullivan rejects it, the Epstein files move into the hands of a special counsel. The pressure is mounting. The deadlines are looming, and the 9:44 a.m. admission has set a countdown in motion that no one can stop. But there is one detail in the transcript we haven't discussed yet. We have to look at the timeline because the timeline is where the criminal liability lives. On April 19, 2026, a specific communication occurred between the White House and the Department of Justice. But here is the thing you need to understand. Judge Emmett Sullivan had already issued a binding production order for the Epstein files. The legal debate was officially over. When a judge orders a document produced, you are no longer debating policy. You are following a court order. Yet, AG Pam Bondi testified that the president reached out anyway. According to the transcript from Saturday at 9:44 a.m., the president communicated that certain materials would not be produced. This included 41 specific names the court had demanded. This is the collision course that transformed a standard document dispute into a potential felony. In the legal world, we call this the transition from privilege to obstruction. If you claim privilege before a judge rules, you are just a lawyer doing your job. If you ignore a final order because of executive direction, you are potentially a co-conspirator. Attorney General Bondi clearly understood the gravity of this moment days before she took the stand. Records show she hired personal counsel independent of the DOJ 4 days prior. That is the move of someone who knows they are being asked to walk into a legal buzzsaw. She wasn't acting as the nation's top law officer. She was acting as a witness. Look at the specific documents in question. The inventory Bondi submitted at 9 a.m. that Saturday was described as defiant. It intentionally missing 41 key names. 3 of those names have already been identified in prior unsealed filings as uncharged co-conspirators. This isn't just about redacting sensitive national security data. We are talking about names already linked to the underlying criminal enterprise of Jeffrey Epstein. When Judge Sullivan asked if the redactions were her independent judgment, the room went silent. The transcript records a 14-second pause. For 14 seconds, Bondi had to choose between her boss and her freedom. She eventually chose her freedom. She admitted the decision followed guidance received from the executive office. That admission at 9:41 a.m. set off a chain reaction currently tearing through the West Wing. By 10:12 a.m., Judge Sullivan called the admission extraordinary and suspended the entire proceeding. He knew exactly what he was looking at, a direct violation of his authority. The White House tried to pivot by 10:47 a.m., calling the testimony imprecise. They argued that general guidance is still protected by executive privilege, but that logic is legally bankrupt. You cannot use privilege as a shield for a post hoc attempt to override a judicial order. That is not how the Constitution works, and every lawyer in that building knows it. This is why Senator Lindsey Graham's sudden shift is so revealing. By 12:47 p.m., Graham joined Dick Durbin in calling for a joint bipartisan emergency hearing for Monday morning. When Lindsey Graham stops defending the president on a legal matter, the matter is likely indefensible. It suggests Graham has seen whistleblower evidence confirming Bondi's account. We are now watching a high-stakes game of legal chicken with a midnight Sunday deadline. The White House has until then to file a formal assertion of privilege. They want to strike Bondi's testimony from the record. If they fail, or if the filing is rejected, Bondi's admission stands as operative fact in this case. If it is an operative fact that the president ordered the suppression of evidence, the case shifts. We are no longer talking about a leak. We are talking about a crime. Judge Sullivan will rule at 9:19 a.m. Monday on whether this testimony stays on the record. 1 hour later, the Senate Judiciary Committee will begin its own emergency hearing. Bondi is already under subpoena to testify further. This time, there is no executive shield left to hide behind. The Department of Justice is effectively in a state of civil war. The DOJ faces a Tuesday deadline to decide if a special counsel is required. This is the domino effect in real time. One name, one order, one phone call on April 19th. That single moment has created the greatest stress test of the American legal system in 50 years. The question isn't just what is in the Epstein files anymore. The question is whether the President of the United States believes he is above the law. We are looking at an attorney general turning state's evidence against her own administration. This is the total breakdown of executive loyalty in the face of criminal exposure. The 41 names remain redacted for now, but the wall of secrecy is finally cracking.